Good morning, everyone. Thank you so much for inviting me to the MLS Breakfast today. What I wanted to talk about today were just some cases that we recently published on the CAR website. I thought it would be interesting just to talk about the kinds of ethics violations that we're seeing right now and the kinds of activities that could potentially get you into hot water. So basically the things to watch out for. But before we get to the recently published cases, I wanted to mention the change to the Code of Ethics for 2019. This is the only thing that's new in the actual Code of Ethics for this year. It is the new language in Standard of Practice 1-7. So the new part is the part that is bolded and underlined. So the first sentence here was always here. When acting as listing brokers, realtors shall continue to submit to the seller or landlord all offers and counteroffers until closing or execution of a lease unless the seller or landlord has waived this obligation in writing. But now there's kind of some teeth to back that up. The next sentence, upon the written request of a cooperating broker who submits an offer to the listing broker shall provide a written affirmation to the cooperating broker stating that the offer has been submitted to the seller or landlord, or a written notification that the seller or landlord has waived the obligation to have the offer presented. So now in the Code of Ethics, the listing broker has an obligation to send something in writing, and that can be by email, it can be just by checking something in a form, but it has to be something in writing if the cooperating broker asks for some proof that the offer has been submitted. So that's the big change for the actual Code of Ethics this year. So now let's talk about some cases that we've published recently on the CAR website. Here's the first one. In this one, the respondent represented his brother in the lease of a property. And his brother indicated to the landlord that he was going through a divorce and needed a place to live. But in fact, after executing the lease, he installed a sober living facility in the property without the knowledge or the consent of the landlord. So evidence was presented at the hearing that the respondent had represented his brother on 2 previous leases where his brother ultimately installed sober living facilities in the properties without the prior consent or knowledge of the landlord. So it seemed like they had this kind of scheme going where they were lying about what they were going to be using these properties for. So here are the violations that were found. The panel concluded that the respondent must have known what his brother intended to do with the property and deliberately withheld that information from the landlord. So the panel found a violation of Article 1 for failing to treat all parties in the transaction honestly. And remember, with Article 1, there's actually 2 prongs to Article 1. You have the first prong, which is the duty to protect and promote the interests of your client. But the next sentence says, even though the duty to the client is primary, it doesn't relieve realtors of the obligation to treat all parties to the transaction honestly. So here there's a violation of that second prong, the duty to treat everyone in the transaction honestly. Article 2 was violated for concealing a pertinent fact about the transaction. And Article 2 is always the article that's related to disclosures of pertinent facts. What Article 2 says specifically is that realtors shall not exaggerate, misrepresent, or conceal pertinent facts about the property or the transaction. And here, the finding was that the realtor did conceal the pertinent fact about the transaction about what the tenant was going to be using the property for. And then finally, we have an Article 11 violation. And Article 11 often gets added on because it's the duty to provide competent service in whatever field of real estate discipline you're offering service in. And here, because of the fact that the realtor was being dishonest, was withholding information, the panel found that the realtor was also not able to provide competent service. All right, so here's our next case. In this one, the respondent represented a client who was selling her property and purchasing another property. And the client needed to rent back the property she was selling and remain a tenant in the property for approximately 1 additional week after the close of escrow. But the respondent failed to adequately assist her client in preparing an addendum to the purchase agreement to effectuate the rent back, and failed to assist her in obtaining an insurance policy to protect her during the rent back period. Additionally, the respondent failed to keep her client apprised of the buyer's loan application process and failed to notify her client that the sale of her home was to be delayed due to the purchaser requiring a hard money loan after the expiration of the contractual contingency. So the contractual paperwork prepared by the respondent was also unclear and poorly organized, which created significant confusion for the seller and the buyer. Then finally, during final walkthrough of the client's purchased property, the client noticed the odor of what appeared to be gas and brought the matter to the attention of the respondent, asking her to check with the listing agent and the seller. The respondent, however, did not follow these instructions, and when the client took possession, the gas company had to carry out an emergency gas shutoff because there was a gas leak. So a lot went wrong in this particular transaction. The panel found 2 violations. Article 1 for failing to protect and promote the interests of the client. That's an obvious violation in this case. And Article 11 for failing to provide competent service. I think there were actually other violations here that the panel maybe didn't even notice, or at least didn't find. The first one I can think of, Article 9. Because remember, Article 9 is the duty to make sure that all agreements are in writing in clear and understandable language. And if we look at the second to last bullet point here, the paperwork wasn't prepared properly. So that's always going to be a violation of Article 9. And yeah, I think that's probably the other article that should have been cited here. Potentially Article 2, but here it's not necessarily a disclosure of something, it's the failure to follow up on the question about the gas leak. So I think Articles 1, 9, and 11 are the proper ones to have been cited here. All right, going on to our next example. In this one, the complainants, who were owners of rental property, asked the respondent to assist them in preparing a new rental agreement which removed one of the 2 existing tenants and added a new tenant. After the tenants had signed the agreement, the complainants requested to the respondent several times that they be provided with a copy of the agreement so that they could sign it. After approximately 5 weeks of futile attempts to receive a copy, the complainants traveled all the way from their home in Nevada to California in order to pick up a physical copy of the agreement and sign it. And the complainants had a difficult time finding the respondent because the address provided by the respondent and his online profile on Zillow was no longer accurate. So the complainants had to go on a bit of a wild goose chase here to find the respondent. So the panel found several violations in this case. First, Article 1, because they found that the respondent failed to protect and promote the client's interests by failing to adequately communicate with the clients and follow up with them to execute the rental agreement. Additionally, the rental agreement included some payment terms that were not agreed to by the complainants, so the respondent violated the Article 9 duty to make sure that all written agreements express the terms agreed to by the parties. And then we have a violation of Article 12 because of the inaccurate Zillow profile. The address and the firm on that profile were out of date, therefore they were not presenting a true picture to the public. And remember, Article 12 is the duty that realtors have to make sure all of their marketing, advertising, and other representations do present a true picture. And then finally, there's a bit of a pattern here. We see a violation of Article 11. And Article 11 does usually get added on to these cases for failure to provide competent service as a property manager. All right, and our next one, the respondent was selling some property that she owned. And she agreed to utilize the services of the complainant by signing a residential listing contract with him. Later, the complainant produced to the respondent an offer to purchase the property, and the respondent rejected the offer. The respondent subsequently signed an offer to purchase with another broker while under contract with the complainant. When the complainant asked the respondent if she had entered into a purchase contract with another broker for the sale of her home, the respondent lied and said she had not. So what this case shows is that you can violate the code of ethics even when you're a principal, even when you're selling your own property. And the code of ethics does say that specifically. So here the violations are of Articles 1 and 2. So Article 1, for failing to treat the complainant honestly. Remember, Article 1 includes the duty to treat all parties to the transaction honestly. And then Article 2, for misrepresenting a pertinent fact about the transaction. In other words, when she lied to the complainant, that was a misrepresentation. All right, our next example. The respondent was the listing agent for a residential property. The complainant, who was a realtor, represented a buyer. After the buyer initially contacted the respondent, she continued to contact the buyer by telephone and email, even though she had been asked by the complainant to discontinue contact. During these conversations, the respondent told the buyer her agent needed to reduce her commission by 1%. Additionally, when communicating with the buyer, the respondent demanded that the buyer remove contingencies when it was not appropriate for her to do so. And finally, the respondent removed the lockbox from the property during the inspection and appraisal time frame, making it impossible for the complainant to access the property for the appraisal. So, several violations. Article 16 is the one that immediately comes to mind because the respondent took actions that were inconsistent with the exclusive representation agreement the complainant had with her client. And that's actually the definition of Article 16, is that realtors always have a duty not to take any action that is inconsistent with exclusive brokerage or exclusive representation agreements that other realtors have with their clients. And this is a pretty textbook example of an Article 16 violation in this case. And again, we have an Article 1 violation because of that duty that's required, which is to treat all parties to the transaction honestly. Here there was a failure to do that. And then finally, we have an Article 3 violation because of a failure to cooperate with other brokers, even when it is in the best interest of the client to do so. And that is what Article 3 says, is that realtors generally have a duty to cooperate with other brokers, except when it's not in the client's best interest. But here there's no defense that the cooperation, that the failure to cooperate was in the client's best interest. So the panel found a violation of Article 3. All right, in this next one, the respondent attempted to negotiate a short sale transaction without using the proper contracts, placing her client in a position where he was evicted from his property and lost his earnest money. She also failed to advise either party of the potential fraud that was being perpetrated on the lender by the issuance of a quitclaim deed that removed the buyer from the title. And she did not disclose that the issuance of a quitclaim deed would not secure the property for the buyer or relieve the seller of his obligation to pay the existing loan. The respondent failed to put the purchase agreement in writing to express the specific terms, conditions, obligations, and commitments of the parties, and didn't use written extensions or amendments when it was necessary. The respondent also admitted at the hearing that she lacked adequate skills and training to handle a residential real estate transaction without the aid of a more experienced agent or broker. And finally, the respondent engaged in the unauthorized practice of law by recommending to her client that he file bankruptcy and helping to initiate a quitclaim deed to transfer the title improperly without obtaining the advice of an attorney. So, you know, clearly the testimony that the respondent needed some help with this transaction was accurate. So we have a bunch of violations here. Article 1, failure to protect and promote the client's interest, clearly if the client was evicted here and all of these things went wrong. Article 2, failure to avoid exaggerating, misrepresenting, or concealing pertinent facts about the property or transaction. Article 9 is also relevant here because of the failure to make sure that the agreements express the terms that the parties had actually agreed to. Article 11, failure to provide competent service, and the agent even testified at the hearing that she wasn't able to do that on her own. And then Article 13, which is one we haven't talked about, the duty not to engage in activities that constitute the unauthorized practice of law. And clearly in this situation, besides asking for the help of a more experienced agent or broker, the agent should have requested the assistance of an attorney with the transfer of title. All right, this last one, we are actually seeing a lot of cases like this. I'm only talking about one of two that we published that are quite similar. So in this one, the respondent posted a photo in an MLS listing that was an edited screenshot of the Google Street View of the property. However, the respondent did not possess ownership or the proper written authorization from Google to utilize Google's copyrighted work. Now, a lot of times we think, oh, Google, it's out there, we can use it. But, Google does own copyrights to these photos that they put on Google Street View. And you can't use them without authorization. So the panel found that the agent's use of this photo was a violation of Article 12 as interpreted by Standard of Practice 12-10. So the Standard of Practice here addresses this situation specifically. Realtors' obligation to present a true picture in their advertising and representations to the public includes internet content, images, and the URLs and domain names they use, and prohibits realtors from doing all of these things. And the key one here is the one I bolded. Presenting content developed by others without either attribution or without permission. And here the photo from Google Street View was presented with no attribution to Google, with no permission from Google. So you have to be careful about the use of photos. It's not just a violation of MLS rules if you do it without permission, it's a violation of the Code of Ethics as well. Well, that's all I have for you today. So I want to thank you for coming, thank you for inviting me. I'll be at the business meetings in Indian Wells if any of you are going to be there, and I'll also be back here to teach Pro Standards volunteers in March. So, thank you.